Prior to 1835, tangata whenua lived together in hapu, or extended family structures in a communal sense, and lived by the customary practices of their hapu. On the 28th of October 1835, a gathering of the hapu o Nutirini by attendants of rangatira was held, and a proclamation of sovereignty was instated by the hereditary chiefs of the hapu by declaration to the royal head of the British Empire, King William IV. This proclamation established the sovereignty of the hapu o Nutirini and set the constitutional order by which Nutirini and ngā hapu would operate, the he whakaputanga o ngā rangatira o ngā hapu o Nutirini 1835. The proclamation of sovereignty, acknowledged by King William IV, was then established in international law and affirmed with the flag of the United Tribes. Hapu were free to continue with their tikanga and customary practices within their customary territories under a constituted order of international law. In 1840, the hereditary chiefs in Congress, ngā rangatira o ngā hapu o Nutirini, accepted the provisions for the settlement of Her Majesty's subjects in Nutirini, signing it into effect on the 6th of February 1840 as Te Tiriti o Waitangi, extending the constitutional order to be inclusive of this, the provisional order. For the Native Council structure, this is the extent of the process, and this is the constitution by which we govern and self-determine. Following on from the provisional order, the settlers in New Zealand were granted warrant to govern themselves in 1846. They instantly applied themselves a sovereign authority capacity and extended their legislative acts to not only govern themselves, but to include tangata whenua, contravening the constitutional order of Nutirini, and more specifically, the sovereign order. As a consequence, many Maori organisations have been established under the rule and authority of the Settlers' Parliament, and it is this Settlers' Parliament that these Maori organisations and most people in New Zealand believe is the law. Under the constitutional order of Nutirini, the Constitution of New Zealand, the settlers are granted warrant to govern themselves by condition of the provisional order, and the provisional order has been granted conditional residency by the sovereign order. By breaching the conditions of the provisional and sovereign orders, the Settlers' Parliament is in breach of the constitutional order of Nutirini, New Zealand. By decree of the sovereign order, the provisional order and subsequent settlers' laws may be absolved at any time, and the law of the sovereign take precedence. The sovereign order holds the absolute power to make laws, to add, alter or delete to any new or existing laws, and is consequently an incredulous state that many cannot accept. They cannot accept that their migrant residency is conditional under the provisional order of the Constitution. So they choose to live under a settler parliament organisation, which has no constitutional foundation and no lawful foundation, and they use their deceptive imitation of a document, the lawfully invalid Treaty of Waitangi, to justify their claimed authority and continue issuing legislation as law. Many still believe the settler organisation, this parliament, to be the law, oblivious to the sovereign order and the sovereign law that governs this territory of Nutirini. For the Native Council structure, it is with lawful application that we appropriate ourselves and authenticate ourselves to the constitutional order of Nutirini, the sovereign order and the provisional order, and we reaffirm our traditional hapu beginnings because first and foremost we are hapu. We relinquish any subsequent minor rules, regulations or so-called law extraneous or foreign to our constitutional order. We place ourselves and constitute ourselves under the authority of law. This, our constitutional order, the he whakaputanga o ngā rangatira o ngā hapu o Nutirini 1835 and Te Tiriti o Waitangi 1840. We are hapu. We are now Hapu in order. The title Native Council is now available to these authenticated Hapu, so as to differentiate between Hapu in order and Hapu in general. Should any settler law or legislation be imposed upon us as tangata whenua, whānau, Hapu, we are able to turn to our constitutional order and absolve any imposed settler authority over us. Hapu in general may process themselves on these settler-imposed matters. Hapu in order, or the native councils, have available a templated process that they can follow. The native council title may be arrested when all matters are cleared. We are, and we will always remain, first and foremost, Hapu.